Welcome to Talkin Divorce with Don and Lori.
Welcome back again. We are talking divorce, and I have Lori McShane with me, my
Hello.
co-host. How are you?
I'm well, and I'm super excited to have our expert guest today.
Karen Darling, thank you for
Hi.
coming.
Thank you. I'm glad to be here too, and I hope I'm really an expert on this one today. Thanks.
You are. Listen, Karen Darling is a minors counsel, and she deals with what goes to the heart of just about every family law case that has children, and that is child custody, what's best for the kids. She does God's work in a lot of ways, and it's sometimes a controversial issue. We'll talk a little bit about that, but we're really going to talk about what Karen does and why she does it and why she's passionate about it. And with that, Lori, it's all on you.
Yes. So, Karen, can you give us a little bit of a background information? Like, what made you go into the Child Minors Counsel?
Okay, actually,
Field.
when I first decided to practice law, I practiced law. I decided to practice law because I was reading a book, and believe it or not, it was about a girl who was in the juvenile dependency system, and that she was not getting the recognition or the representation that she needed. And so that was what made me decide to go into law. What's interesting, though, is prior to actually becoming a minors counsel, I was in private practice and also at the Attorney General's office. So it was a little path, a little segue before I actually got involved in family law and minors counsel work. But I ended up exactly the reason why I decided to go into law in the first place.
You've been blessed that you've had transitions in your career as a lawyer that a lot of lawyers don't have. So you started off in private practice, which was a great experience.
It was.
That probably segued into working for the government. And were you a prosecutor?
Actually, when you're with the Attorney General's office, you can be a prosecutor, but I was with the tort section, so I was actually defending the state and all of its employees and agencies.
Wow.
Yeah, so it was great. And like you said, what was so wonderful about it is because I was in the private sector, I got a feeling for what it was like to be working for individuals, private individuals. But then when I was with the Attorney General's office, I was representing the state, a public entity, and there's a whole new realm of laws and codes and everything on that. But it gave me a lot of experience, a lot of knowledge that when I went into family law, I had a really good, solid background.
Big time. I mean, you're coming in after all that experience, really having probably more experience in the courtroom than 98% of the family law attorneys, and that the responsibility that you were carrying, that feeling that you can do it, transitions very well into what you're doing now. The only difference is that now you're pursuing God's work, right?
Thank you.
You're representing children.
Yes, and it was great because I got to do cases from start to finish, and you really, because you're doing trial work and appellate work, you really understand for other things, among other things, how important the rules of evidence are, and getting your information, your evidence in properly so it can support what you're trying to argue.
This is going to be great for those people that are going through a family law case, whether it's a divorce, a child custody case, just a paternity case with people who have been married, but they don't know what minors counsel is.
I was thinking that, in real basic form.
And they tend to demonize sometimes the minors counsel. So Lori's going to help us with your help kind of demystify all of that and let us know what it really is all about.
Okay.
Yeah, so let's just start with the basics. Like, what exactly is a minors counsel, and what is it that you do?
Okay. First of all, basically, minors counsel represents the children. And in a family law case, which is a high conflict case, a lot of times what the judge wants is to appoint minors counsel because we get a mother who's making one set of narrative facts, a father who's saying another set of narrative facts, and somewhere in between the two of them, hopefully, is the truth. But the other thing that's happening is you've got the family the two parents who are advocating for what they want, what's important to them. Nobody's thinking about what's best for the child. And so what ends up happening is the judge decides we need to have someone here be the voice of the child, not just because we don't want to bring a child into court and have them testify, but also because we want someone to advocate for the child and do some further investigation, a lot of times I'm called upon to contact the schools. If there's a medical issue, I contact the doctors, I talk to the therapists, I talk to collateral witnesses. So a lot of times what I can do is I can take the time, get a lot of different information, talk to my clients, find out what exactly is going on, and then go into court and provide a report to the court about what's exactly happening, what is going on with this child and what's in the best interest of the child.
Okay, so you're truly the voice of the child.
Yes.
So is that how you would make it different than just being in just a family law attorney?
That's one of the main differences. Is that when the attorney who's representing the mother is going to advocate for mother. Likewise, the attorney for father, and they're going to advocate for the father, even if sometimes, unfortunately, it's contrary to what's best for the child. And so what ends up happening is I don't have confidentiality with mother or her attorney. I don't have confidentiality with father or his attorney or same-sex marriage. I don't have a confidentiality with anyone. My confidentiality is with my client, the children. So I do talk to both parents, and I find out what their narrative is, what they're claiming, and I'll go back and forth with them. If I feel like their narratives are so different, I'll go back and forth with both of them and say, your wife said this, your ex-husband said this, what's your response to this? Just so I can go back to the judge and say, this is what I think the narrative is.
And the real value, Lori, is those cases where you just know that the judge isn't really getting the information he or she needs to make a sound decision for the best interest of the child. Give you an example. I was in court just yesterday, and of course, the opposing party is painting my client as being, a horrible co-parent, somebody who is a helicopter mom, somebody who is only thinking of herself and, is making bad decisions about education and medicine. Now the child's 16 years old. Right, and the father, on the other hand, is being accused of being a non-existent parent, and somebody that is only thinking about child support, and if he gets more custody, he pays less. And you're hearing two attorneys who are really good at arguing, talking about facts that haven't really been tested yet, because it's not necessarily a real evidentiary hearing. You're at the not the trial stage, but one of those what we call penente lite stages, where we're just trying to get some temporary orders. And it's unfair, because what happens is those temporary orders could become permanent orders very easily, and it tends to create a status quo. So if we could convince the court that, hey, why don't you order minors counsel to really get to the story, because minors counsel is going to help you, judge, make these decisions, and it really kind of falls on the attorneys to be the adults in the room and saying we need minors counsel. Now you're going to see a fight sometimes about, hey, I don't want minors counsel, because that you're kind of convincing the court, one way or the other.
Right.
But to me, before you grab that child's right to a good life and a development stage that they need, all the protections that a child needs, before you take that away, why don't you take that extra step and order minors counsel? I just can't see why, in most cases, you wouldn't order one if they're available.
Right. It's because I have no allegiance to mother or father, just the child. All I care about is what's in the best interest of the child. And a lot of times we'll get parents who say, well, I just want what's best for my child. But when they're arguing or advocating or standing up for what they want, it's not in the best interest of the child. And that's why it's so important to have minors counsel there, because I'm not a neutral person, but I have I don't care what mom thinks. I don't care what dad thinks. All I care about is what's best for the child, and the judge knows that. And so a lot of what I say carries a lot of weight, because they know that I'm not out to be on the side of one parent or the other. I'm just there for what's best for the child.
So what does the process look like, especially if the child is, not a teenager and doesn't really know what's going on, and maybe they're 5 or 6 and, they see mom and dad argue and they're like, oh, So how does that process work when you come in and you advocate for that child?
Okay, great question. What I do is I start out and I always meet with my child in person, or children in person, just because, it's a better situation. I want them to start establish some kind of relationship with me, because I'm asking them to trust me. I'm asking them to tell me things that maybe that they don't want to share or that are embarrassing, and I need them to trust me that I'm going to be taking care of them and I'm going to be a voice for them. So I try and establish a good, close, honest relationship with them. And I will be honest with them, and I will tell them, I will never lie to you. I will never promise something I can't do for you. I may not be able to get what you want, but I will tell you that. You know, I'm always going to be honest with them about what I can and can't do. And part of that is saying, you know, I will tell the judge what you want, what your concerns are, what you would prefer to have happen, or what you're afraid of, or what's bothering you. I said, and I will also tell the judge what you want and what you would prefer. I said, but the judge may not agree, because what the child wants isn't always what's in their best interest. Otherwise, a child would be not going to school and eating ice cream every day. So I'm very careful to make sure that they know that they have a voice, and I'll share it with the judge, but they may not get exactly what they want because they're a child. They don't know what that is. But then what I'll do is I'll also meet with the parents, and I don't just meet with them one time. I meet with them as many times as I need to. Same thing with collateral witnesses, doctors, therapists, everybody. So I can get as many objective views and narratives as possible, so I can figure out what's best for the child from different perspectives, not just from the parties who are directly involved.
And do you share that information with the child shares with you to the parents, or do you just only share it with the court or the attorneys, or how does that work?
It depends. It depends. The thing is, because I have a confidentiality agreement with the child, I make it very clear, if you ever don't want me to say anything, I won't say anything. And sometimes a child is afraid of saying anything negative about a parent because they don't want that parent to get mad at them.
Yeah.
And so sometimes it's difficult because you want to get a certain message across, but you don't want to be telling the court what the child said. So sometimes there's other ways of doing that, maybe collateral witnesses, or I heard it from the other parent, or I heard it from the therapist. So there's other ways of doing that without breaking that confidentiality with the child. But a lot of times the child is an open book. And
Yeah.
they don't necessarily have a lot of horrible things to say about their parents. They're just not happy with the situation. And sometimes it is more egregious, where you have a parent that maybe is saying and doing some inappropriate things. And a lot of times they say, it's okay to tell the judge this, it's okay to go into court on this, because this is serious and we need something to change.
You know, I would love to be a fly on the wall when you're talking to the kids.
Yes.
So how open do they get with you, and do they, you know, once you get their confidence and everything, you know, because I just imagine, I mean, you know, no family's perfect, you know, and, you know, but, you know, a child that's involved in a family dispute, you know, where you're hearing a lot of arguing, and, you know that, you know, people aren't happy and it's disruptive and stuff like that. Do they open up with you about how it feels, and, you know, they get sensitive with you?
They do. The thing is that you always have to be aware of that there are some children that just are not as forthcoming, and they would be the same way if they were talking to a relative or the other parent. Sometimes you really got to drag it out of them. Other times, the child maybe is not affected by it as much. Like a lot of times, like I have a case right now where the daughter, who's like 13, has a lot to say. The younger child, who's 8, doesn't have as much to say because he's just not as cognizant of it. Mm-hmm. So they do open up, they do share things. The other thing you always have to balance, too, is what's accurate, what's exaggerated. I mean, how many times do we say to a child, well, how many times did your sister take your candy bar? Oh, all the time, hundreds of times, and every time it's Halloween, takes all my candy. Well, it didn't happen all the time. So you sometimes have to figure out what is an exaggeration with a child and what's accurate.
Well, along those lines, if you don't mind, Lori,
Yeah.
There are some parents that try to pre-program the child before they meet you, as I assume.
Oh, yeah.
It's human nature. I know that it
I was
happens.
just thinking that.
What do you have any methods that you kind of figure out if that's happening, and how do you deal with that?
Sometimes, and I have met with some children many, many, many times, and sometimes in person, sometimes Zoom, sometimes over the phone. And sometimes you do have to have several meetings with a child to be able to get to what's actually happening. Sometimes, like a first meeting is kind of an introductory meeting, getting some general information. And then when things start happening and the child thinks, oh, this is working, this is getting better, then they start trusting me more. Maybe they'll share a little bit more with me. A lot of times, it depends on what the situation is. It depends on how egregious the behavior or the concern is from the child. But usually I'm able to get them to share with me and open up right away. And then a lot of times a good follow-up visit a lot of times is warranted, not just to get that information, but sometimes in the future too, because things will maybe get a little bit better, but then something else will go south or something like that.
So they share with you their fears?
Yes.
Because, I mean, every parent that I've ever represented, whether they're the one that wants the divorce or the one that doesn't want the divorce, there's emotions that go sky high, and right at the top of that is fear. Fear of what the future is going to be like, because they're so used to, the status quo and being in a lifestyle. I'm thinking now, from talking to you, that children must have that fear like crazy. Like, where are we going to live? How often am I going to see my parents and stuff? Do you get into those conversations?
We do, and children do have fears. They have fears of the unknown, fears that they don't have control over certain things, and they really don't. And sometimes that's why they rebel and try so hard to control what little minuscule thing they can control, because that's all they have. But a lot of times what I do with children, and I do have two of my own that are older, but I give my clients examples. I'll because I understand their fears, and I'll sit there and give them an example of something that happened with my children, or something that me as a parent I've had to undergo. Like I've said to children, I've had to apologize to my children. I've had to, and it was a difficult thing to do, because I'm an adult and I should know everything and I should know better. But adults make mistakes too, and showing some vulnerability, showing that it's okay to make mistakes, showing that it's okay for an adult to make a mistake, that it's okay for the child to be caught lying. Showing some vulnerability, and that it's okay to be afraid, and that you're not the only one that this is happening to. It's happened to me. It's happened to my personal children as well, or in other cases. It really helps, because then it doesn't sound quite so bad, or quite so frightening or scary or awful to have to articulate this, because it happens to other people, other children.
Wow. Are there any common misconceptions that people may seem of a children's minors counsel?
Sometimes what you do, I've gotten the one where someone will say, I'm biased, or I'm not neutral, and the judge has responded to that and said, well, yeah, she is biased. She's not neutral. She's for her client. She's advocating for her client. But sometimes I will get that, because if you've got two parents that are just totally different narratives, and maybe one of them is not quite so child-centered and attuned to what's in the child's best interest, sometimes they'll get angry because I'm not seeing their side of it, and all of a sudden you're not the friend so much, or they're not talking to you. They think you're out to get them, and unfortunately, it's because this is a parent who maybe cannot see that they are not looking out for the child's best interest. They are looking out for their own personal interests. And I've got several cases where the one of the parents is thinking that I'm being unfair, and I'm hearing the other parent's side of it, and not hearing their side of it, and being biased and unfair. And it really is because this parent really is not child-centered, which is the whole reason why minors counsel was a good idea in the first place, because you've got a parent who's convinced that they're out there for the right reasons and looking out for their child, and they're really not.
So that kind of goes full circle to when we began the podcast, that I talked about how I've seen people demonize minors counsel clients, opposing parties. You must get a lot of that, and how does that make you feel, and how do you cope with people that hate you because you're not finding things the way that they want you to see it?
It doesn't bother me at all. And I think part of it's because of the experience. I mean, when you've been practicing law for a while and you get older, you kind of you consider the source. And so, the negativity or something, you're like, okay, I'm thinking about where it's coming from, and I know what I'm doing, and I've been practicing for a while. And the other thing too is I'm very good at what I do, and I'm very thorough at what I do. And I'm not biased. I'm not unfair. And I will talk with both parents. I will look at both of their allegations. I will go back and forth with them. I will call every single one of their collateral witnesses. I will do, and when I go into court, I don't just present one side of it. I present both sides of it because the judge wants the facts so the judge can make the best decision. So I know that I'm not biased. I'm not being unfair, and I'm not looking at something from one parent's perspective as opposed to the other. So when that's their opinion, I'm like, well, I'm sorry they feel that way, but I know it's not true.
But there is a moment of truth that every family law attorney experiences when there's minors counsel, Lori, and that is you don't know necessarily what minors counsel is going to say when they go into court. Sometimes they'll give you a courtesy call, and we'll have like a phone conference like before the court date. So, and that's kind of the moment of truth, is you're waiting to hear, okay, what are you going to say when you go into court? And it's like waiting for a jury verdict. Your heart's going like this because you want to do well for your client, and stuff. But do you know that that's a tense moment for the attorneys?
It is, because they're advocating for their client, and they're afraid their client is going to get mad at them because they're not successful, they're not getting their way. But what I also do, though, too, is one of the reasons I am so thorough is because I can come up with a reason or a request that I'm giving to the judge about what I would like the judge to do, and I've got backup for it. Nothing comes out of thin air without any kind of support for it. There's a basis or a reason for it.
Do you ever have attorneys try to talk you out of it after you've given them your assessment and what you're going to say to the court?
Yeah, they'll a lot of times they'll do that more like if we do a meet and confer or a conversation before, and I'm going to listen to them.
Okay.
And I'm always going to listen to them just like I would listen to the parents, because they're advocating, and I'm here to listen to both sides of it and come up with the best request for my client. And if they come up with an argument or a reason that I hadn't thought of, or maybe I had misconceptions or did not have the facts right or something, I want to know that, because then I want to follow through and do my job. But that really doesn't happen because I know that I've done everything I can. And if they do come up with something, maybe it's because it's a new witness that they hadn't told me about before or something like that. But then I'll just follow through and talk to that witness or follow up with that information. But usually it's something that really doesn't sway my opinion, because I've already thought about it, and it doesn't change it. There's too much on the other side to support what I'm requesting.
I've noticed that judges tend to appoint minors counsel without input from the attorneys, which I think is a good thing. Although sometimes we want to steer it one way or the other. But are you on a judge's list? Is that how that works? It seems like they kind of go, well, this case could use Karen Darling, versus somebody else. It's kind of interesting how they try to size the minors counsel with the children and the family and stuff.
Well, I hope they always do that, and that's why I work so hard, and other minors counsels work so hard to give the judge what they need, because that's our reputation. There's basically two ways of being appointed. One of them is through, we call it PACE, it's through the county, where and a lot of times it happens with an improper parents that are representing themselves, and the county pays for it. Sometimes it's another way. It's called private pay, and the parents have to pay for it, and they usually split it down the middle, and they each pay half of it. And usually when it's a PACE case, when the county's paying for it, the judge will just appoint whatever minors counsel. And there's a lot of minors counsel, but there's some that are really, really good. Mm-hmm. Some that are probably have a special, maybe a forte or something like that a judge will consider. But a judge is always going to go with a minors counsel that's going to do a good job and get the information that the judge needs. Otherwise, we've just wasted all this time on someone who's just not thorough or doesn't know what they're doing or isn't paying attention to what minors counsel should do. So I like it when the judge knows best, knows the facts of the case, knows the minors counsels that are available, and would appoint someone that would be best for that case. Because we all have like a little niche. We all have things that we're better at, or maybe we have a little bit of education at, or even in a situation where someone speaks another language. That's going to be important too sometimes.